Zach here, back again. Here's the problem for this situation. So, Donald, 28 years old, married with a 2-year-old, also has a 7-year-old child from a previous relationship. He has a mortgage on his house, his own plumbing business, no employees yet. He has no retirement account. His spouse is also 28 years old, and their 2-year-old is her only child. So, would you recommend an estate planning vehicle? What would you recommend? And then going forward from there, if Donald is also the beneficiary of his grandparents' trust and he'll someday inherit 200 acres of farmland, does he need to do anything differently? Why or why not? So, first of all, yes, everybody should have some sort of formal planning. That's an easy one. If he wants his spouse to inherit everything, then he's going to need a vehicle because under Iowa intestacy law, it would be half to his child from outside the marriage and then half to his surviving spouse, with some caveats associated with that. But if he wants everything to go to his current spouse, he's going to need last will and testament. Ideally with a contingent beneficiary trust. So if you have minor children, it's ideal to help out, make sure that the minor child has some sort of protection associated with them. If Donald or his spouse dies, the other would inherit everything through the will, and then the business has no real value now, so it by itself isn't a probate trigger. So if one of them is still alive, then the survivor should get everything pretty easily. If both die in an accident and they have the contingent beneficiary trust, then the child would have some protection. That is a probate trigger, but since they're minor, their name won't ever appear, so there won't be any privacy issues. So we can solve that pretty easily. If the plumbing business grows, then we need a plan for the plumbing business. So if it has its own inherent value, we need some plan for if it winds up, if it needs to go to successors, is Junior going to take over, that sort of fun stuff. Once children have aged out of the trust, then they probably need just a revocable living trust. At a certain age, you need to be planning for all of your assets together. There's nothing we can do to plan about future inheritance of farmland. It is a good idea for your estate planner to know about that, to know that there are options waiting for you, to know that you need to come back and talk to them about that. But there's no certainty that you'll receive it, and there's nothing to do with a hypothetical inheritance to begin with. That said, it would be interesting if that farm were in a trust. There might be a power of appointment, so it would be worthwhile to have that trust document for the estate planner as well. And once Donald inherits it, he should consider getting long-term care insurance, putting it in a revocable trust, having some plan to protect it for Medicaid asset protection. Okay.